what I'm going to be talking about is not all, but most of the major tenancy reform provisions that are contained in the Act, in the Bill, predominantly in Part 1. Chapter 1 contains the headline-making provisions which abolish assured shorthold tenancies and therefore bring about the end of Section 21, in England anyway. So there'll be no more no-fault eviction processes. There are new grounds for possession, some of which I will cover, all of which are contained in the annex to my notes. There's a new right to request permission to keep a pet. And there are new statutory rent increase procedures and various other reforms. Chapter 3 of the Bill includes new prohibitions on discrimination in relation to children. The Chapter 6 contains provisions which are designed to avoid rental bidding, and Chapter 7 contains miscellaneous provisions, including penalties for unlawful eviction and harassment of occupiers, and as well as extending Awaab's law to the private rented sector. So the background to the bill, it's something that tenant organisations have been campaigning for a long, long time. Shelter have had a huge campaign about it. The previous Conservative government introduced a renters reform bill, announced that it intended in 2019 to abolish no-fault evictions. However, that bill, I suppose, within the Conservative Party wasn't without some degree of controversy. It didn't, surprisingly, get passed before the last general election, wasn't top of their priorities. But the Labour Party, their manifesto committed to giving greater rights and protections to people renting their homes, including by abolishing Section 21, no-fault evictions, and reforming the grounds for possession. So the new Renters' Right Bill effectively builds on and develops the Renters' Reform Bill 6 years and 4 prime ministers after it was originally announced. And it does bring about the most significant change to the private rented sector in at least 30 years. It will also have obvious implications for social housing as well, for reasons that we'll come on to, but it is predominantly the private rented sector that is affected. So what's the status quo? So right now, assured shorthold tenancies are the default in the private rented sector. Following the Housing Act 1988, that's the statutory framework for assured and assured shorthold tenancies. When the Act was amended in 1996, it made ASTs the default. So if a tenancy was granted under that Act, it was an AST unless it was set out to be an assured shorthold tenancy. Prior to that, it had been the other way around. Fully assured tenancies, as we all know, provide greater security of tenure, generally offered into tenants of social housing. But ASTs are used in the social housing sector, particularly as things like 12-month starter tenancies and so on. So as I say, there will be implications for social housing providers as a result of these changes. Some impact on shared ownership leases, which are technically treated as ASTs, which we'll come on to. At the moment, ASTs are the most common form of private rented sector tenancy in England. They're 19% of households in England, whereas social housing tenants are 16% of households in England. There's a survey from Shelter in 2024 that found that 40% of renters said that their last home move was forced on them. So, for example, fixed-term tenancy has ended, an eviction notice, and so on. So, huge uncertainty for people in the private rented sector, which this legislation is aiming to rectify and offer longer-term security. As we know, at the moment, Section 21 notice enables landlords to repossess the properties without having to establish fault on behalf of the tenant. Possession claims can be issued under the accelerated procedure. The idea being that so long as procedural requirements are complied with, a possession order will be entered into. It's a quick and easy procedure for landlords. However, as I'm sure we all know, the Section 21 procedure has actually become anything but simple. Landlords have to establish compliance with tenancy deposit rules, gas safety, EPCs, how to rent guide, and every new piece of regulation that's been introduced to try and provide additional security and support for tenants that's introduced those various things has caused a huge spate of litigation, lots and lots of cases. So every piece of legislative reform, I mean, it keeps us in business because they never stop changing housing law, and there's always things to challenge and always things going on. I'm sure this will be no different. So what is the difference? How are they going to do it? So the major reform, Clause 1 of the bill, will amend the Housing Act 1988 to provide that as soon as it comes into force, all assured tenancies, both new and existing, must be periodic tenancies. So it will no longer be possible to have a fixed term assured tenancy. And any terms in tenancy agreements that try to create a fixed term will have no legal effect. The rental periods of the periodic assured tenancies will have to be either monthly or 4 weekly, so 28 days. And assured tenancies which try to create any other length of periodic tenancy will be of no effect. So no more fixed terms. On the face of it, my first thought was, but surely tenants want fixed terms. Like, that provides them with some degree of security. It provides a period of time when you can't be evicted. But when you think about it, because it's Clause 2 is going to omit the provisions that relate to ASTs, there will be no more assured shorthold tenancies. There will be no more Section 21. All tenants will be fully assured on a periodic tenancy, and there will be a degree of security therefore afforded to everyone, because you can only be evicted if you breach your agreement and if one of the grounds of possession apply. So it is a huge, huge change. As I say, I don't doubt there's going to be a significant amount of litigation and lots of cases, especially in the early days, particularly because the changes will apply on commencement. The guidance suggests there's going to be a later date for the social housing sector because they need to apparently consult with the regulator. I think it says the government intends to do this as quickly as possible, but it must first update and consult on its direction to the regulator of social housing, who can then update the tenancy standard to ensure that registered providers of social housing are clear on their obligations under the new regime. So whether or not that comes into fruition, I don't know, but that's what the intention is. There are transitional provisions in the bill. So for circumstances where prior to the commencement date, someone's on an ASD and has been served with a Section 21 notice, or what is going to be an old version of the Section 8 notice, because there'll be a new set of grounds under Section 8 as well. If the notice is served before the commencement date and a possession claim is sent to the court to be issued but hasn't been issued yet, that will still be valid. The notice will still be valid, and those proceedings can still go ahead on the basis of that notice. Where a notice has been served but a possession claim hasn't been sent to the court yet, so it hasn't been issued, there will be a 3-month transitional period from the start of the Act coming into force when claims can be made. So I think what we may expect, depending on how quickly this comes in, is a spate of Section 21 notices being served, proceedings being issued. And because you normally have the 6-month period, what you'll actually have is a slightly truncated 3-month period from commencement date. That may be, I suppose, an unintended consequence of the way it's going to happen, but it is certainly what I envisage is going to happen. Whether or not those notices are valid and things are complied with is a whole different question. As I said before, some unintended consequences. On first glance, I thought the unavailability of fixed terms was problematic. But having thought about it, I think, given the abolition of the ASTs, that's not as much of a problem as I would have thought. However, what could still be an issue is that the rule about not having a fixed term was originally going to apply to tenancies under 7 years. It has now been extended from January. They changed it in January, so it will prohibit fixed term leases of less than 21 years. And I think that possibly is going to have some unintended consequences, because you may have people being granted a 20-year lease, which is now effectively going to become an assured periodic tenancy. The problem with that being that people entering into those agreements may have had, for example, Section 11 wouldn't have applied if they had decided between them to have in the tenancy agreement or in the lease that the tenant who's going to be there for 20 years would take responsibility for repairs. Now they're going to be pulled into, fall under Section 11 repairing obligations applying. Whether or not the finalised bill does anything about that, I don't know. This is still in bill form. It's still going through. but they are expecting it to come in either the end of this year or early next year. And so far, amendments that have been proposed haven't got particularly far. So we shall see. There's also an effect, as I said earlier, on the shared ownership leases, because post-implementation of the Housing Act 1988, those were effectively ASTs and could be terminated as such. Now that will no longer be possible. Shared ownership leases, if you want to terminate them, would have to go down forfeiture proceedings route. And it's not even clear which kind of notice should be used. So there's a whole host of potential issues there as well. The new grounds then. There's an increased threshold and notice period for mandatory rent arrears grounds. So it was the 2 month, it's now going up to 3 month arrears. And the notice period could have been 2 weeks, that's now going up to 4 weeks. There's also a new ground for landlords who want to sell their property, that's going to be ground 1A, and an amended ground 1 for landlords who wish to move close family members into the property. This is, I suppose, to provide some degree of protection for small landlords that might have one property or something like that. There's new grounds for possession for supported accommodation, homelessness accommodation, and what is called stepping stone accommodation. Again, all to ensure that the type of accommodation that's supposed to be provided short-term to people can still be provided short-term. And there are specific grounds for example, someone in supported accommodation who no longer needs that support, they'll still be able to move them on. They're not stuck there forever. There's an expanded ground 6 for redevelopment by social landlords, and a specific possession ground 6A for decant accommodation, which I think is really important, provided by relevant social landlords. There's also a reduced notice period for serious antisocial behaviour, so that claims can be made immediately. So the notice will be immediately. There's an amended section 9A, which is the discretionary ground for antisocial behaviour. Currently says that the court has to consider the effect that nuisance or annoyance has on the people other than the person against whom the order is sought, that they have to take into account any continuing effect that the nuisance or annoyance is likely to have on such persons, and the effect that it would likely have if the conduct is repeated. Under the bill, the court will also have to give weight to the impact on other tenants in HMOs specifically, and on whether the tenant has cooperated with any attempts by the landlord to encourage the conduct to cease. So expect lots of arguments about non-engagement, which we can have a separate conversation about, because I'm very much of the view that saying non-engagement is not sufficient, and you really need to ensure, if you're a landlord, that you actually are trying to engage someone and can evidence doing that. That is possibly going to become even more important now, because if you're going along to court and saying, well, they haven't engaged, you're going to need to prove it, and you're going to need to show what exactly you have done. And sending a letter or making a call or sending one text is probably not going to be sufficient. Rent increases then. There's been concern in the sector that rent increases are used unfairly in the private rented sector, because a landlord can increase the rent during fixed term by including a rent review clause in the agreement, and the rents on periodic tenancies can be increased annually by a Section 13 notice. But the availability of Section 21 has historically discouraged tenants from challenging rent increases, because the thought process being, landlord hikes up your rent, you try and challenge it, they'll just serve you with a Section 21 and tell you to get out and move someone else in. Under the bill, the only way most landlords could increase rent will be by using the Section 13 notice. Clause 6 will amend Section 13 and introduce a new Section 13A, which will apply to low-cost tenancies, which will be your social housing tenancies. And Section 13B, which helpfully provides that the first-tier tribunal may determine the validity of a Section 13 notice. Previously, it was considered that only the court could determine whether a notice was valid, and all a tribunal could do was decide whether or not the proposed rent increase was, well, what the proposed rent increase should be. Clause 7 will amend Section 14 and introduce new Sections 14, ZA and B. And under those provisions, the new rent determined by the tribunal cannot be more than the rent proposed by the landlord. That was another disincentive previously for tenants to challenge rent increases, was the tribunal could have turned around and said, actually, market rent is more, and it could have gone up even more. Now the tribunal cannot do that. It can only be the same that the landlord suggested or less. The aim of all of this is to ensure that tenants feel confident enough to challenge poor practice and enforce their rights. So in 2021, the English Private Landlord Survey showed that almost half of landlords were unwilling to let to tenants with pets. Clause 11 of the bill will amend the Housing Act 1988 to insert new sections 16A to C. And those provisions make it an implied term of assured tenancies that tenants may keep a pet with the landlord's consent, and such consent is not to be unreasonably refused by the landlord. Some of you will be relieved to know that those provisions do not apply to social housing. A survey of private landlords commissioned by Shelter in 2019 found that 63% of landlords did not or preferred not to let to people who receive housing benefit. Most of us will remember and have seen the no DSS adverts. I suspect you still see them now. There's been a historic problem with private landlords refusing to let to people on welfare benefits. The county courts have ruled, you may remember a couple of county court cases within the last few years in which judges have ruled unlawful indirect discrimination on the grounds of sex and disability, where no DSS policies were required by private landlords and letting agents, but they're only county court decisions. In 2013, the Property Ombudsman ruled that a blanket ban on renting to households with children breached the equalities rules in its code of practice because they disproportionately affected women. So the bill aims to remedy this, and clause 34 and 35 will make it unlawful for landlords and agents to engage in discriminatory conduct against tenants with children or those who receive benefits. And that will include kind of the direct practice of refusing to let to someone and indirect practices such as saying to someone, well, yes, you can let it even though you're on benefits, but you have to pay 6-month rent up front or something like that. All of that kind of practice will be discriminatory. Conduct will not be discriminatory if it's a proportionate means of achieving a legitimate aim, nor will it be discriminatory if it's required and intended to avoid a breach of the landlord's insurance policy. But that will cease to apply at some point because clause 39 of the Act provides that discriminatory terms of policies entered into following implementation of the bill will be of no effect. So if you're a landlord and you say, well, my insurance doesn't let me let to people on benefits, right now, that would be fine. Once the Act comes into force, if they try and enter into a new policy with that term in, the insurance term will be void. So they won't be able to rely on that. Yeah, discriminatory terms, clauses 36 to 39 essentially provide that discriminatory terms relating to children or benefit status in a tenancy agreement, superior lease, mortgage or insurance contract will have no effect. And clause 40 gives the Secretary of State the power to extend the rental discrimination provisions to additional groups of people in future if required. Maybe people with pets, who knows, we'll see. Clause 41 will give local housing authorities the power to impose a financial penalty of up to £7,000 for a breach of the rental discrimination provisions. So these clauses and provisions, whilst don't affect social housing in that way, local authorities do certainly need to be aware of what's going on, particularly the homelessness teams or housing teams or support teams who are putting people into private rented sector accommodation with people that might need support to ensure this type of discrimination does not happen. And if it does, that the local authority has policies and procedures in place for using its powers to impose a financial penalty. Again, can't wait for this to happen. Clause 42 clarifies landlords and letting agents will still be able to consider the income of a prospective tenant when considering affordability. Last but not least, and I have not covered this in a huge degree of detail in my notes, is rental bidding. Clause 57 will prohibit landlords and letting agents from inviting, encouraging or accepting a tenant's offer to pay rent above the advertised rate. So where a property is really sought after and a tenant offers to pay above the asking price to secure it, they're not going to be able to do that anymore. And clause 58 will give local authorities the power to penalise landlords if they breach that clause.